Filing bankruptcy in Oklahoma City can provide powerful debt relief, but it is important to understand the mandatory fees involved before starting the process. Many people focus only on attorney fees, but bankruptcy also involves court filing fees, required credit counseling costs, debtor education costs, and other expenses that may apply depending on the chapter filed and the facts of the case. The exact cost of filing bankruptcy depends on whether you file Chapter 7, Chapter 13, Chapter 11, or another type of bankruptcy. For most individuals and families, the two most common options are Chapter 7 and Chapter 13. Mandatory bankruptcy court filing fees. The court filing fee is one of the main mandatory fees in a bankruptcy case. This is paid to the bankruptcy court when the case is filed, unless the court allows payment in installments or, in limited Chapter 7 cases, grants a fee waiver. In Oklahoma City, bankruptcy cases are usually filed in the Western District of Oklahoma. The current filing fee for a Chapter 7 voluntary petition is $338. The current filing fee for a Chapter 13 voluntary petition is $313. These fees are set by the federal court system and may change over time. A Chapter 7 case is often used by individuals seeking a discharge of qualifying unsecured debts. A Chapter 13 case is used by individuals with regular income who propose a repayment plan over time. Although Chapter 13 has a lower fee than Chapter 7, it usually lasts much longer and involves ongoing plan payments. Credit counseling fee. Before filing bankruptcy, individual debtors must complete a credit counseling course from an approved provider. This course must usually be completed before the bankruptcy petition is filed. After completion, the debtor receives a certificate that must be filed with the bankruptcy court. The cost of credit counseling varies by provider. Many approved providers offer the course online or by telephone, and the cost is often modest. Some providers may offer reduced fees or waivers for low-income debtors. Even though the cost may be small compared to other bankruptcy expenses, the course is still important because failing to complete it before filing can create serious problems in the case. Debtor education or financial management course. After filing bankruptcy, individual debtors must usually complete a second course called Debtor Education or Personal Financial Management. This course is different from the pre-filing credit counseling course. It must be completed after the case is filed and before discharge. The Debtor Education course also requires a certificate of completion. If the debtor does not complete the course and file the certificate on time, the court may close the case without issuing a discharge. That means the debtor may go through much of the bankruptcy process without receiving the debt relief they expected. Cost of credit reports and financial records. Although not always described as a court fee, many bankruptcy cases require the debtor to obtain credit reports, pay stubs, tax returns, bank statements, vehicle loan information, mortgage information, retirement account statements, and other financial documents. Some of these documents may be free, but others may incur a small fee. Accurate financial information is essential. A bankruptcy petition must list debts, assets, income, expenses, transfers, lawsuits, garnishments, and other financial information. Missing or inaccurate information can delay the case, cause amendments, or create disputes with the trustee or creditors. Amendment fees. If a debtor needs to amend certain bankruptcy schedules after filing, the court may charge an amendment fee. Amendments may be necessary if a creditor was accidentally omitted, an address was incorrect, a debt was missed, or other information needs to be corrected. The better approach is to gather complete information before filing so the petition is as accurate as possible from the beginning. However, when amendments are necessary, debtors should address them promptly. Reaffirmation, redemption, and other mandatory fees. Some Chapter 7 debtors may need to decide whether to reaffirm a secured debt, redeem property, surrender collateral, or negotiate with a creditor. These issues often arise with vehicle, furniture, and jewelry loans, as well as other secured debts. While not every debtor will pay additional court fees for these issues, they may involve attorney time, creditor negotiations, or additional paperwork. Debtors should understand these options before filing, as decisions about secured debts can affect whether they keep or surrender specific property. Chapter 13 Trustee and Plan Payments. In Chapter 13, the debtor proposes a repayment plan. The plan payment is not a filing fee, but it is a required part of the case. The debtor must make monthly payments to the Chapter 13 trustee, who distributes funds according to the confirmed plan. The amount of the Chapter 13 payment depends on income, expenses, secured debts, priority debts, tax obligations, arrearages, disposable income, and the value of non-exempt property. Chapter the 13th may also include trustee fees as part of the plan administration. For this reason, Chapter 13 costs should be evaluated as part of the full repayment plan, not merely by looking at the filing fee. Attorney fees. Attorney fees are separate from court filing fees and required course fees. The amount depends on the chapter filed, the complexity of the case, the number of creditors, whether lawsuits or garnishments are pending, whether assets are at risk, and whether the case involves business debts, tax debts, domestic support obligations, real estate, or prior bankruptcy filings. Although some people file without an attorney, bankruptcy law is technical. Mistakes can result in dismissed cases, loss of property, denial of discharge, or unnecessary disputes with creditors and trustees. For many debtors, legal representation is one of the most important costs associated with filing. Can the filing fee be waived or paid in installments? In some Chapter 7 cases, a debtor may ask the court to waive the filing fee if the debtor meets the legal requirements. If the court does not waive the fee, the debtor may ask to pay the filing fee in installments. Chapter 13 filing fees are generally paid through the case process or at filing, depending on local practice and attorney arrangements. A debtor should not assume that a fee waiver will be granted. The court reviews eligibility, income, and circumstances before deciding whether to waive the Chapter 7 filing fee. Bankruptcy can stop garnishments, collection lawsuits, creditor harassment, repossessions, and other collection activity in many cases. However, the process requires careful preparation. The more important question is whether bankruptcy will protect your property, discharge your debts, and solve the financial problem you are facing.